Good morning, Ms. Balanoff.
Good morning. I'm here this morning for Mark Mosher, who is appealing his conviction on the first-degree murder of David Tokars and other offenses in the Worcester Superior Court, as well as the denial of his motion for new trial. And I plan to address three issues this morning, principally whether Theodore Harris, who was Mr. Mosher's trial counsel and who was suspended from the practice of law by this court for 18 months for, among other things, conflict of interest and lying to a court, had a conflict of interest in Mr. Mosher's case due to his representation of the Commonwealth witness Craig Bosse. If I have some time, I'll also touch on the related issue of whether Mr. Harris failed to provide effective assistance of counsel and whether the closing argument was risked a miscarriage of justice.
With respect to the first point that you are going to talk about, does it depend for its premise that, well, I guess the actual conflict does, that at the time Mr. Harris was representing both Mr. Is it Bosse? Is that how you say it? Bosse, as well as the defendant. I mean, is that a necessary premise for the actual conflict argument, that it's simultaneous representation?
Yes, that's the main premise. There is also the issue of whether Mr. Bosse still owed Mr. Harris money, but
the judge found that he didn't.
That's correct, and ordinarily I think that would settle matters on that part of the conflict issue, but the problem is that his finding on that issue was tainted in part by his statement that Mr. Harris had testified that defense counsel almost always get paid up front, and there was no such testimony.
Well, that's separate, but that's separate. He disbelieved the defendant, that the defendant hadn't fully paid him.
He did not accept Mr. Bosse's testimony that
he disbelieved
that
it.
money was still,
and he found
was money still owed.
Did the defense attorney ever testify that he was actually fully paid?
He did.
Okay, so he believed that, and we have to accept his finding, and it's warranted by the evidence.
He did, but in deciding to credit Mr. Harris's testimony, part of the reasons that he gave was he said that Harris testified defense counsel are always paid up front, and Harris didn't give that testimony. But I think the principal issue on the conflict is whether Mr. Bosse's case was still open at the time he testified.
And I guess the question I have there is do we need to accept, I mean, should it be that when you've got a continuance without a finding that you don't look at when it was entered, you should look at it entirely until it closes? I mean, that's what you're saying,
yes,
right?
I think that's
contrary to well-established district court procedure, and this judge had been a district court judge, and I would say could take judicial notice from all his years before that that's not the practice. I mean, and generally the lawyer considers it's over when the quaff is entered, doesn't come back with the defendant. Defendant's on his own then. Just as this defendant did come back with another lawyer, is pointed out when he had to come back.
Years and years later.
Well, that's what happens. It's years and years later.
I think you start from the premise that under the case law, a continuance without a finding by definition means that a case isn't concluded, it's continued, it's open, and there is the possibility of resumption of prosecution, which has occurred in a couple of cases that I've cited. And the Eaton case is actually quite interesting because in that case, the Commonwealth...
Does that mean that if the defendant represented by counsel is sent to jail and doesn't get paroled because of some misconduct, does the representation continue until the sentence is concluded?
No, I think that's different.
Why?
I think parole revocation, probation revocation, those are separate proceedings that are triggered later on. This is a continuance of the initial case.
Yeah, but it's a continuance that is contingent upon the person not doing any misconduct during the course of that period, just as parole is.
Well, the difficulty here is the case is still open, and in this particular case, Mr. Bosse is set to testify for the Commonwealth. And the Commonwealth could have been greatly displeased if he went out of his way to help Mr. Mosher, or if his testimony indicated he was more deeply involved in this murder of Mr. Tokarz than they had thought. So, and we're in the same part of the Commonwealth. We're still in Worcester County. The idea that the Commonwealth might try to resume this prosecution is not fanciful. They were opposed to the continuance without a finding.
But as the judge
place.
said, you would, if we conclude the way you're advocating, this would turn long-standing defense practice on its head.
Well,
The lawyer considers the case is over when he walks out. He's done a good job for his client if he's gotten a quaff.
I think essentially the judge was taking judicial notice of that without any notice that that was going to happen. And while he might be aware of what happens in his courtroom, if anything, on the day that a case is dismissed, he would not be, he can't take judicial notice of whether defense counsel remains attentive to the case, pays attention to the fact that it's going to be called.
You're telling me that every time a defense lawyer gets a quaff for the client, he continues watching the case?
There's nothing on the record to suggest
I take it
otherwise, that someone wouldn't check to make sure that a case is dismissed.
It seemed to me that the piece of your argument that made the most sense was to say on cross-examination, you've got a quaff for this person, you may never see them again. You don't, that's fine. But now he's in front of you, i.e. you have to cross-examine him. I mean, that's what brings this back into focus, because at that point, presumably, the attorney realizes this is the guy that I got a quaff for, and I better tread gingerly here because he's been called as a Commonwealth Commonwealth witness, correct?
That's concern. It's
I
analogous.
I didn't understand. Commonwealth said that he's a Commonwealth witness. You mentioned in your brief that he was a defense witness at one point.
No, I don't think. The Commonwealth argued that he was friendly to the defense. He was certainly called by the Commonwealth. The Commonwealth goes to great lengths to say he did these wonderful things for the defense, but a lot of the testimony he gave was covered otherwise. For example, yes, he testified that the defendant told him he did not do the killing, but the defendant told the police that, and the defendant's testimony came in. So I think the fact of the matter is that the prosecutor thought it was very worthwhile to call him, examine him at length, and made hay out of some of his testimony in the opening and the closing.
You're correct, but the Commonwealth is the one that says the defense considered him a defense witness, and I didn't understand that. Maybe you don't understand it either.
I think they're relying on Mr. Harris's testimony that in some sense he considered him friendly to the defense, but he was called by the Commonwealth.
Yes,
I think,
no
didn't he say that he would have called him if the Commonwealth had not?
He did.
Help me to understand. Let's assume Mr. Harris never met Mr. Bosse. What are you saying a reasonable attorney without a conflict could have accomplished on cross during the course of this case based on this record?
On this record, there's plenty to suggest that he could have done that he did not do. Two of the most disturbing omissions have to do with his failure to question Mr. Bosse or Mr. Bosse's ex-wife, Annette Broberg, who happened to also be the girlfriend of Mr. Tokarz, about whether some dark-skinned people, not Mr. Mosher, had killed Mr. Tokarz.
But wasn't that ruled inadmissible hearsay? There was no way to get that in?
No, he didn't try to get that in. He had, in the discovery, information that Annette Broberg first told Mr. Tokarz's brother that this was the case, that she was there, some dark-skinned people killed Mr. Tokarz, and Mosher was being framed or had nothing to do with it. And then she backtracked and told...
How would that come in through Bosse?
Well, and then she told police...
How would it come in
no,
through
Bosse
Bosse?
told me that. Either of them, Bosse or Broberg, could have been directly questioned with no hearsay problem at all. Were you there when two dark-skinned men killed Tokarz? Were you there when someone other than Mosher killed Tokarz? And if they resisted, then the prior statements could be used, either through the police or John Tokarz. There were plenty of options, but he did none of that. So you had this whole somebody else, some dark-skinned people did this, not Mosher, that never came up. He did nothing with that. And then there is the evidence about the threat from the vigilantes, which he did nothing to present, despite ample information in the.
But wasn't it true that at trial, Bossy said he was no longer a member? So what could the attorney do once he said that?
Well, he did say that. Of course, part of the conflict situation is what was somebody who had represented or was still representing, in our view, Bossy going to do? Press him about whether he's still in a motorcycle club?
But wasn't there also evidence that the defendant was a member of the same motorcycle club?
There wasn't any.
Well, because the defense had tried to get that excluded, and it had succeeded in doing so. And if he, the defense lawyer, started bringing up that Bossy was a member of the motorcycle club, then the Commonwealth could have justifiably introduced evidence showing the defendant's connection to the motorcycle club, and that which the defendant had successfully kept out.
Well,
so
there
that would hurt the
there
defendant.
wasn't any evidence at trial that Mr. Mosher was a member of this club. There was some testimony about this club at trial.
That was because the defendant moved to keep it out, and it was kept out.
The motion was directed at some motorcycle World War II Nazi paraphernalia that was found in the house that Mosher and Bossé shared. And that was actually kept out by agreement. But there wasn't any evidence at trial that Mr. Mosher was a member of the Vigilantes. Quite the contrary. He was the one who didn't have a license, who didn't have a car, who didn't have a motorcycle, and who was always bumming rides from everybody else.
Attorney Baronoff, could you help me out on this? I want to follow through with you. How would questioning Bossé on these two matters, whether Bossé was present when two dark-skinned people killed the victim, or whether he was a member of the Vigilantes, how would his having questioned Bossé on either or both of those two matters have jeopardized the quaff?
Well, it would have indicated that Mr. Bossé could have been more deeply involved in
If
this.
two dark-skinned people had killed the victim, how would that have implicated Mr. Bossé? That would have taken everybody off the hook. I mean, everybody in the present group.
It would have indicated that he was involved somehow in covering up or not telling the truth at trial. And the Vigilantes'
That's
evidence.
very speculative.
Pardon?
Isn't that very speculative? That he was involved in a cover-up?
Well, let me step back a little bit. Of course, if there is simultaneous representation and an actual conflict, then the court doesn't get into exactly
No prejudice.
what could have happened.
Right.
But if we don't agree with you, and we're exploring the issue of whether there was a potential conflict, how would cross-examination on these subjects have jeopardized the quaff?
Well, on the
What would
Vigilantes-
have motivated Attorney Harris not to cross-examine him because he didn't want to jeopardize the quaff?
Well, on the Vigilantes' evidence, Bossé was the one who had belonged to the Vigilantes. I realize that he said, and briefly in his testimony, he wasn't active or he was retired or whatever. But bringing up information about the Vigilantes having been behind this, I think, would raise a question about whether Mr. Bossé was involved. Because
Despite
he was
the fact
one
that
who had
Bossy said he
connection.
wasn't a member of the Vigilantes.
Pardon?
And despite the fact Bossy said he was no longer a member of the
He
Vigilantes.
did, but there was ample evidence that he was the one who was still riding motorcycles. And
Well, you can
You
ride a
can ride
motorcycle.
motorcycles without being a member. I mean, and what do you do? I mean, that's a typical problem that a lawyer has. If a witness at trial says no, and you don't have any evidence of yes, then there's not too much you can do. Unless you present other evidence, some other witness who says, yes, he is a member, but that's not alleged here.
I think I want to make very clear how harmful it was that this evidence wasn't introduced. That might not have been exactly what you were asking, but I think it's important.
No, well,
not to
I
lose
am.
sight of
That is what I'm asking, and I'm especially focusing on how it would have affected the quaff, how it could have jeopardized Bossé's status as a person who was free.
Well, Well, to show a potential, you don't have to necessarily tie it to the clock, do you?
I don't think so. I don't think so. You just have to show that the defense was adversely affected if you're under federal law, or that there was prejudice, or if you're under the potential conflict situation here. And if there's a potential conflict, if the court isn't persuaded there's an actual conflict, there is actual prejudice by virtue of not introducing this vigilante's evidence, because the defendant had said in his statement, which was introduced at trial, I think I didn't do it, and I think Tokars was killed because he owed somebody a lot of money. And Mr. Harris also indicated to the court that that was going to be his defense, but there was never any evidence of it. This evidence about the vigilantes and their threat because they were owed $60,000 would have supplied that link. And without that evidence, there was no such support for the theory that Mr. Mosher himself introduced into the trial through his statement, and that his lawyer at the time said he was going to pursue. What happened here was that Mr. Harris thought this information was inadmissible. He thought it was hearsay, and that's why he didn't introduce it. Or at least that if it wasn't a conflict issue that was eating at his mind, it was the misconception that he couldn't get this information in. And he was wrong about that. We've gone into great lengths in our brief to try to explain all the various ways in which state of mind, state of police knowledge, third-party culprit evidence would have allowed him to introduce this evidence in whole or in part. So there's ample actual evidence of prejudice, adverse effect on the defense, and there were other aspects that he did not resort to that we've touched on in our brief. Untrue statements to the police when he first was interviewed, his prior convictions, the possibility of animosity between him and Tokars, about the child support, money, children. So all of these were problems. The ineffective assistance of counsel issue is related. Much of what I've said about the adverse effect, the substantial prejudice demonstrates ineffectiveness as well as supports the finding of a conflict that requires reversal. And there were more deficiencies that I've talked about in my brief, among them the failure to call Megan Martone to testify that Osipov, one of the other possible shooters, had offered to knock off or bump off her boss because he does that. I'd like to touch a little bit on the closing argument as well, although I'll answer any further questions people have on the conflict and the ineffectiveness.
Well, on the
of
closing
counsel
argument,
issue.
wasn't what the prosecutor was saying was that this isn't a joint venture theory. I don't think he was suggesting that. He was just stating what the defendant wanted the jury to believe, that this guy could have done it, that guy could have done it, and that guy could have done it. But then he said there's no evidence that the others did it, and this defendant had control over them anyway. At least that's how I read the
Well, I
closing
think
argument.
it's kind of a mess, and what the Commonwealth doesn't...
Well, closing arguments aren't always written out in practice as much as they should be beforehand. So, I mean, it seems to me that that's what the prosecutor was saying.
Well, a couple of things here. I think this interjected a whole new idea into the case. This case was prosecuted on the theory that Mr. Mosher was the shooter.
But that's why your argument doesn't make sense, because the prosecutor didn't ask for joint venture instruction, didn't try it as a joint venture, so what she, I don't even know what it was saying wasn't joint venture, it was just a discussion of the defendant's evidence, and this doesn't work because this guy has control over these people anyway.
Well, you have to look at both parts of the closing argument that we're complaining about, not just the first part that the prosecutor addresses in her brief, but when the prosecutor who tried the case went on to argue essentially you had three options. You can determine that Osipov went alone to kill Tokars, Mosher was with Osipov when Tokars was killed, or Mosher went to kill Tokars himself. He was suggesting if you look at that in the context of his earlier argument that if Mr. Mosher somehow controlled Osipov or someone else, or somehow participated at the scene but wasn't the one who did the shooting, that he could be found guilty. And this at the last moment interjected a whole new idea and theory into the case.
This looks like, I mean, this is just a combing of the record to come up with something that, you know, wasn't meant or understood by anybody at the time as what you're suggesting is what it seems to me.
Well, I think this was another thing which found Mr. Harris either sitting on his hands or not adequately addressing in the defense of this case. We think this is a case where the trial judge didn't have the opportunity to address most of the problems that we see here. He didn't know about the conflict. It was never disclosed to him, this representation of Basset, and he wasn't in a position to know about the evidence that wasn't presented. The motion judge had an opportunity to do justice, but on the law and on some of his findings which were not based on the record or misconstrued the record, he came out the wrong way, we would suggest. There's enough in this case, more than enough in this case, to disturb the court and to justify relief under 278-33E.
Thank you, Ms. Palinoff. Good morning, Ms. Lazar-Moore.
Good morning. Ellen Lazar-Moore for the Commonwealth.
How do you respond to the defendant's claims that the failure to question the witness Bossy about the two dark-skinned people who killed the victim and his membership in the motorcycle club represented at least a potential conflict of interest?
Well, first, Your Honor, it's our
But
position.
were evidence that could have jeopardized the coif, I should say.
And the Commonwealth disagrees with that. First, the defendant, if I could take a step back for a minute, Judge Curran correctly concluded, based upon the evidence that he found credible, that Harris did not have a conflict of interest because he no longer represented Bossy, and Bossy did not owe him any money at the time of the trial. The defendant did not show that his interests were ever at odds with Bossy, and he did not show that Harris's cross-examining Bossy in the way that he now contends he should have would have jeopardized Bossy in any way and helped the defendant at the same time. With regard to those particular pieces of evidence, there was never any suggestion in the record that Bossy committed this crime or could have been implicated in it. If there was testimony that two brown-skinned men or dark-skinned men had committed the crime, that would not have implicated Bossy in any way. It's the Commonwealth's position
What about the defendant's claim that it could have compromised Bossy because Bossy might have been found to have impeded the investigation in some way? There is a charge of obstruction of justice.
And, Your Honor, if you look at what the defendant is submitting that this questioning would have been based upon, it's police reports and statements, which, if you look at them, shows that all of these pieces of evidence were multi-level hearsay.
Well, the defense counsel just said that Mr. Harris could have asked Bossy, were you there when two dark-skinned people killed the victim? I assume he would have said no, so he would have gotten nowhere, but he could have asked the question.
I suppose he could have, although you're, of course, supposed to have a good faith basis for cross-examination.
Well,
you're not supposed to
is there
just...
something in some police report or somewhere that somebody said that?
There's something in some police report that at one point Annette Broberg told John Tokars that this happened, and
that
then...
two brown-skinned people.
That two
Okay,
dark-skinned
so
people
basis,
did it.
so he
And
could
then
ask it.
Harris attempted to question John Tokars about it at trial, and it was excluded as hearsay. And then, if you look at the police reports...
Well, no, it's not did you hear, but what about the question, were you there when two dark-skinned people? That's not hearsay.
No, and I suppose he could have, but Bossé would have said no. It would not have gotten the defense anywhere. And if you take a step back and look at the case as a whole, both with regard to the conflict of interest claim and the ineffective assistance claim, the attorney had a strategy. The defendant, two of his best friends, Osipov and Potter, who were with him on the night of the killing, have now implicated him. They know details of the crime, and and they're blaming the defendant. And the attorney has to find a way to explain that and exonerate the defendant. So his strategy is to undermine those two witnesses and perhaps point the finger at them. That was a reasonable strategy. The fact that it did not succeed does not show that he had a conflict of
Well,
interest,
wouldn't it
does
have-
not show that it was unreasonable.
One of these two best friends was Bossy, right?
No, the Bosse was the third friend,
Oh, wow.
and he was the friend who was helpful to the defendant. So Harris did not want to make him look bad. He wanted him to be credible. He was a prosecution witness in name only, and that's when I said Harris considered him a defense witness. The prosecution called him to testify, but Harris had met with him, had gone over his testimony, was planning to call him. He was happy that the prosecution called him because then he could lead him through the testimony they had gone over. When he testified on direct, he was so uncooperative to the prosecutor, and yet when he testified on cross, he was totally cooperative and helpful with Mr. Harris. The single piece of evidence which the defendant claims was crucial to the prosecution that came in through Bosse was his testimony that the defendant told him that shortly before the murder, the victim came to the defendant's house demanding money and that the defendant slammed the door in his face. But that was cumulative of other evidence that came in through the defendant's own statement to police. He told the police, the last time I saw him, he came to my house demanding this money that I owed him, and I told him to go home and sleep it off. And there was also testimony from...
But Bossy was the only one who said that the defendant said that he slammed the door in his face.
He said he slammed the door, and the defendant told the police. I told him he was bullshit, and I told him to go home and sleep it off. And then there was additional testimony from the victim's brother, who lived almost across the street from the defendant, that on that same day, the victim came to his house and parked in his driveway, walked to the defendant's house, came back within 10 minutes, very angry and upset. So if you put together those two pieces of evidence, it's the equivalent of what Bosse said. By contrast, Harris elicited a ton of evidence helpful to the defense through Bosse, including that when Mosher and Bosse were not getting along, Mosher would leave the house for weeks at a time. So this undermined the Commonwealth's claim that the defendant was in hiding for the week after the crime. He also elicited through Bosse that Osipov had a key to the house. So that helped his argument, the defendant's argument, that Osipov himself committed the crime and then planted some evidence, some clothing among the defendant's clothing. Because, again, Osipov knew details of this crime, and the defense attorney had to find a way to explain how he knew that. He also elicited through Bosse that the defendant was too big to fit in Osipov's truck and that the seat did not slide back, so that the defendant could not have driven that truck to the killing. He first elicited through Bosse evidence that this other person, Matt Thorne, who was another person who they tried to implicate, was in town around the time of the killing, and that the victim had given Thorne money to launder and had demanded it back with interest, so there was a motive for Thorne to kill him. The judge ended up striking it after Bosse testified to that, saying that it was hearsay, but the defense attorney later elicited it through another witness. He also was able to elicit through Bosse that when Bosse spoke to the defendant denied committing the crime. I mean, he elicited all of this through Bosse without having to put the defendant on the stand and risking exposing him to cross-examination.
What about the defense's claim that Harris should have questioned Bosse more about his membership in the Vigilante Club, or should have questioned him at all about that?
Well, two things. First, as I said, Harris wanted Bosse to be credible to the jury. He was a witness that Harris considered helpful. Here are the defendant's 3 of his best friends, all with him on the night of the murder. 2 are implicating him, 1 is not. The one who is not is giving all of this helpful evidence that may implicate other people and may explain why the 2 friends who are implicating him, why they know about the crime. The second thing is that Harris, or I believe it may have been the prosecutor who asked whether Bosse was in the Vigilantes, but in any event, Bosse said, no, I retired from that 5 or 6 years ago. the evidence that the defendant now claims should have been presented to show any connection with the vigilantes at all didn't so much have to do with Bosse's connection to it, but with the suggestion that maybe the vigilantes committed the crime. As I argued in the brief, first, Harris had succeeded in keeping out evidence that connected the defendant to the vigilantes.
What was
When
that
the
evidence?
defendant-
The defendant said
It was
that-
not only Nazi garb, it was Nazi and vigilante garb that was seized from the defendant's house after his arrest. Harris had moved to exclude that, and the prosecutor agreed not to use it. But if the defendant had tried to open it up by showing that maybe the vigilantes committed the crime, then of course the prosecutor would have tried to put in evidence connecting the defendant to the vigilantes. Also, it remains the Commonwealth position that this evidence was 4 or 5 level hearsay. There may have been some exception to get in 1 level of hearsay, but this was Gentili supposedly said to Philbin, who told Francois, who told Garapi, who told Broberg, who told the police, that Gentili made a remark about a flaming redhead in Barry. So even if you can assume that this was referring to Broberg, which is speculative to begin with, you have all these levels of hearsay, and then when the police go to try to confirm any of this, Gentili and Matalonis deny knowing any of the people, deny knowing each other, deny knowing the victim, the defendant, any of the people involved, deny even knowing about the murder. And even when the bartender on duty that night is shown photos of these people, he says he doesn't recognize them. Broberg says she doesn't know about anybody owing anybody any money. So, it's easy to say after the fact, well, look, this is in one of the police reports. But as a practical matter, there was no way for the attorney to get this in. And again, if he had, it could have been hurtful to the defendant, who was shown to have a link to this group himself. And as I said earlier, the attorney had a strategy, and it was a good strategy. And the fact that it did not work does not mean that it wasn't reasonable or that he was not effective.
Do you agree that Attorney Harris had at least a potential conflict here?
No, I don't think it was even a potential conflict. His representation of Bosse was done, and as I've said, the defendant has never shown where his interests and Bosse's were adverse at any time. They were best friends. Bosse was supporting him. There's no suggestion anywhere that Bosse could have been implicated in the crime. When Bosse was charged with his crimes, which were totally unrelated to these crimes, Mosher said, hey, have this great attorney, give him a call, and referred Bosse there. I don't believe that he's shown even a potential conflict, but if he has, everything I have said has shown that there was no prejudice from that.
So if it's not a potential conflict, then you're saying that there was no obligation to notify his client that he had previously represented this person?
No, although the judge found that the defendant knew because the defendant had referred him there. But no, there would have been no obligation because I don't believe there was even a potential conflict in these circumstances. As to the closing argument, there was no objection, and it did not create a substantial likelihood of a miscarriage of justice because the prosecutor correctly recited the evidence. And in these 2 passages that the defendant is now challenging, which are actually 22 pages apart, even though the defendant argues that they should be taken together, in the first one, the prosecutor is simply saying, essentially, the defendant is saying, this one did it, and then he says, but that's not your evidence. In the second one, yes, he says, these are different scenarios. Either Osipov could have done it, or Mosher could have done it and told Osipov about it, or Osipov was with Mosher when it was done. But he doesn't say, find the defendant liable in any of those scenarios. He says, these are the ways that Osipov could have known all these details of the crime. He's not saying, and in any of those situations, you should find him liable after he's gone through all the evidence of why the defendant should have done it. He's saying, essentially, look, Osipov came in here, he told you all this stuff, he knew these details. How do you think he knew? Because the defendant told him, as Osipov testified. And again, most importantly, the judge did not instruct on joint venture. The judge said the defendant could be convicted only if the jury found that the defendant personally committed these acts. So there was no risk that the jury, based upon these two separate parts of this closing argument, would have convicted the defendant based upon someone else's acts. If the court has no further questions, I would just rest on my brief for the remainder of the claims.
Thank you, Ms.
Thank you.
Zamora.